this button too. Want to welcome everybody here today. I'm Jackie Kiviat, the Executive Director of Dade County Bar Association. Thank you everyone for getting up early and joining us here. We so appreciate it. And we want to give a special shout out to Holland and Knight, who is our sponsor today and host of the program. So let's thank them. I want to give special thanks to our event producer, Karen Lattis, who is the Executive Director of Dade Legal Aid. So thank you, Karen, and has done so much for this program and in the community in general. And also, I want to thank all of the great organizations that have worked together to make this possible and lent their names to the program today. The Americans for Immigrant Justice, the Caribbean Bar Association, Catholic Legal Services, Gwen Cherry, Black Women Lawyers Association, Haitian Lawyers Association, Miami-Dade FAWL, South Miami Kendall Bar Association, Wilkie Ferguson Bar Association, of course, again, Dade Legal Aid and Put Something Back, and my own Dade, and our own Dade County Bar Association and our Young Lawyer section. So thank you to everyone, because working together, we can accomplish so much more. So it makes all the difference. It's now my great honor and privilege to introduce another great organizer of today's event, Patricia Lise. Many of you know Patricia, to my right here. Patricia has done so much for the community. She is such a shining example of a community leader, has served as a former president of the Haitian Bar Association, has Haitian Lawyers Association, and has worked with the Haitian American Chamber of Commerce, serves on their board and on their executive board, has been recognized by the Miami Herald and asked to participate in their CEO roundtable, and the list goes on and on and on, which some of you may know, but maybe not everyone. We also are celebrating with Patricia, who's just become engaged. Because we need a balance in life. There's so much to celebrate, both personally and professionally, and that's what we hope to do. I would be remiss if I didn't also point out that we are personally grateful at the Dade County Bar Association, because Patricia, along with Melissa Pena, serve as the co-chairs of our immigration committee. And this is the year of the committee. So if you don't belong to the Dade County Bar Association or to one of our committees, please come on out. We'll be sending information about October 24th. We have a committee fair. You'll get to meet and speak with all of our committee co-chairs, like Melissa and Patricia and others, and really get involved. So we're going to be working with and through our committees, and we want to see all of you participate as well. Again, thank you to everyone. And Patricia, I'll hand it off to you.
Sure.
Thank you.
Thank you so much. Before we get started, I want to give the floor to Karen, who did an amazing job with Dade Legal Aid putting together this event. So once again, if you guys can give her a round of applause, because if it wasn't for her, today would not happen. Thank you so much.
I want to welcome everyone today to an overview of DACA and TPS, presented by the Dade County Bar and Dade Legal Aid Immigration Committee in conjunction with each one of you. And as Jackie said, thank you to each of the voluntary bar associations and partnering legal service organizations that focus on immigration. We're very grateful, and we're also very grateful to Holland and Knight for hosting us today. So thank you very much. DACA and TPS are set to expire within the next year, affecting potentially thousands of people in South Florida and across the state, and everywhere. Today, our speakers will be training you on how to handle immigration for these clients who currently have DACA and TPS. Our phenomenal panelists will cover the history and the current state of DACA and TPS. And I am just so delighted to have my colleague here, Patricia, who I've known so long and had the pleasure to work with through the Dade County Bar Association and the great works of the Haitian Lawyers Association, to tell you a little bit more about the speakers and the topics today. And it's just so great to be here with you today.
Before we let you go, though, can you give our participants a little bit more information on how to sign up for Bono opportunities?
Absolutely. There's wonderful organizations right here in Miami that focus on the pro bono work, and two of the organizations are the speakers today from AIJ and Catholic Legal Services, and Put Something Back serves as a clearinghouse for pro bono opportunities. So there's some paperwork out there about clinics that are coming up with AIJ and Catholic Legal Services, and opportunities in general from Put Something Back, how to volunteer in immigration. Don't do immigration, you need a mentor, just let us know, and Put Something Back will be sure to do that. We also cover your malpractice insurance on cases handled through the program. For those of you who may be practicing in other cities, we also encourage you to contact your local legal aid provider to get involved and take on a pro bono case. Thank you very much.
Thank you for that. So just to piggyback off of what Karen is saying, when I first started practicing immigration law, one way that I really learned different areas and different kind of cases was to take on a pro bono case. That way you really have a supervising attorney, either through state legal aid, Put Something Back. I know that the American Immigration Lawyers Association, AILA, the local chapter, also encourages pro bono work, and they will walk you through the case. And not only are you able to give back to the community, help an individual, a local family, but you're also learning and, growing professionally and personally. So I really do encourage everyone to sign up for a pro bono case and try to make a difference in someone's life. Thank you for being here.
Thank you.
So before we get into the panel, again, my name is Patricia Elize from the Dade County Bar Association, especially the Immigration Committee. For those of you who don't know, the Dade County Bar is literally the oldest volunteer bar association in Florida. This upcoming year, we'll be inducting our 103rd president, and it's the biggest as well voluntary bar association. So I encourage everyone to look into joining. We do have a committee hot off the press. We have an event coming up October 24th. October 24th is going to be circulated. A committee fair where you have the opportunity to come out and ask the Immigration Committee some more information about what we do, our goals, along with all the other committees that you may be interested in volunteering with. Welcome. Great. If you can have a seat at the end, please. Thank you. Hi. So that's my spiel for DCBA. And the goal of the Immigration Committee is to put on more events like this, more CLEs, to really help people who are interested in immigration get more involved, to promote pro bono opportunities, to do some volunteer work along with networking, and that sort of thing. So today we're focusing on TPS and DACA. One of the reasons we're doing that is because folks that have TPS and DACA are really in a box of their own, right? They have so many exceptions and so many special rules that apply to them that a lot of people have misconceptions, or they really don't understand how to go about handling one of those cases. Whenever I have a potential client that comes into my office and we sit down and we speak, I always take a second and get, okay, let me put on my TPS hat, okay, let me put on my DACA hat. And there's a lot of information out there, and the law is changing almost every other week as to what you should or should not do with a TPS or DACA recipient. So that's the reason why we decided to put on this CLE today. Now, just really quickly, if we can have a quick poll, how many people actually practice immigration currently? Okay, that's great. So most of you in the room are going to be learning a lot today. So we're really excited to have you, and we're excited to, to have you participate and hopefully take on a case today. So my role today is going to be more of I'm not a panelist, I'm more of a moderator. So I'll be introducing everyone and making sure everyone stays on time. I may be interjecting just to make sure that everyone understands the basics. So if we need to clarify anything, I'll interject. And at the end, we'll be taking questions from our audience. So just very quickly, our presenters today, Peterson, St. Philip. We have Lori Jean, Melissa Pena, as well as Adonia Simpson. and I'll be introducing them before they speak. So the first speaker today is Peterson, and he'll be giving us the background as to what is TPS, what is DACA, what's happened, where are we now, before we go on and move on to our next panels. So Peterson St. Philip, he's a supervising attorney at Catholic Legal Services. He received his JD from Stetson University College of Law. He began his career as an Equal Justice Works Fellow at Gulf Coast Legal Services in St. Petersburg. Peterson has been with Catholic Legal Services since 2012, and his work focuses primarily on deportation defense. Additionally, Peterson manages Catholic Services Legal Orientation Program at the Chrome Detention Center, as well as the Broward Transitional Center. And he's also EOIR's National Qualified Representative Program in Miami. Thank you so much, Peterson. If you can. It's recording.
Okay, from here?
Yeah.
So the PowerPoint's not up or anything? Just pass
Yeah.
it out?
Let me. We had it on. Sorry.
You did refresh the computer maybe?
Is the computer on? Computer's on.
It's moving on the screen.
Sorry, we had it up. Maybe if
And up?
went to sleep a little bit.
It's moving forward on the screen.
Sorry.
Start your finger over there. Maybe that's it.
Kristen, they need, I don't want to do anything from us with presentation. See, I was wondering why our pictures weren't on there, because if they're videoing it, and I was thinking they're just audio recording, but it should be on there.
You have
Video.html.
The audio's here and it's recording.
Okay, so you're just trying to get started without it?
Sure.
You
Right.
do? I think she's getting them.
Oh, actually, wait.
Okay.
Do you want
But
us
it
to
was
put this?
working before.
Oh, so wait,
I'm
what do you
moving
do?
that one. I have no
Peterson?
Nice to meet you. Are you sure we haven't met at like some other event or something?
I'm sure we've seen each other around, so
Yeah.
I've never
You, installation, no.
Okay, they're gonna send someone, but do you want to start
Technology.
and
Yeah, I don't mind. I think everyone has the PowerPoints, right? No?
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 The speakers have the PowerPoints, but we can
provide.
share the PowerPoints with everyone after the CLE.
Okay.
But they're gonna send someone in a little bit.
Fair enough. My name again is Peterson St. Philip. I'm a supervising attorney with Catholic Charities. I'm here today to talk to you a little bit about TPS and what it is. Just going to be giving you a brief overview of what it is. We don't want to get too complicated today. And I think honestly TPS is a pretty simple thing. It's just clear instructions that you need to follow. And it's something that's been around a very long time. It's actually in the regulations. It can be found at section 8 CFR 244 and also in the INA at section 244. What TPS is temporary protected status. It is a status that's afforded to nationals of certain countries who have are either went through a really tough situation like civil war or gone through something like a national disaster. Currently, there are about 10 countries that are currently designated for TPS, and one of those countries is the country that I'm from, Haiti. Haiti was designated for TPS back in 2010 following the earthquake that killed almost 200,000 people. Similarly, countries like Honduras, El Salvador has also been designated for TPS due to certain natural disasters. Honduras has been designated since 1999, El Salvador about the same time as well. One of the biggest issues that people who don't like TPS have with TPS is that it tends not to be temporary like it says in its name, that it turns out to be permanent, but in reality it's not supposed to be a permanent status. It's supposed to be a status that's accorded to nationals of a certain country that suffered natural disaster or is going through civil strife or civil war, where the country either is not in a position to accept the nationals of that country back, or the nationals of that country are not able to go back to their home country. Okay, but it's supposed to be a temporary status that should end at a very specific time. Now, by statute, TPS can be designated for either 6 months, 12 months, or 18 months. Historically, we've always seen that TPS is designated for the full period, 18 months. And prior to the expiration of the 18-month designation, usually the person who actually designate the country for TPS, who is the Secretary of Homeland Security, they do what's called a review to determine whether that status should continue or if it should end. In a lot of cases, like for example, Haiti is one of those countries that was designated about 8 years ago, and recently the president or the Secretary of Homeland Security decided that they're going to terminate TPS status for Haiti. Now, they gave Haiti an 18-month period to determine, well, for nationals of Haiti to decide that they're going to go back to their country voluntarily. However, when that period ends, if nationals of the country do not go back, then they're in the country unlawfully, unless they can do something either through a family member, by being a victim of a crime, or some other way to legalize their status. But the temporary status that they had will actually expire when the last extension of TPS for Haiti is due to expire. So now, who is eligible for TPS? The power. Oh, what's up? Can we go back one more? Forward. There we go. Specifically, these are the specific requirements for someone to be eligible for TPS. For the most part, this is not something that you would have to determine right now, because most likely the cases that you would be taking on are people that already have TPS. But in order for someone to be eligible, you need to be a national of a country designated for TPS by the Secretary of Homeland Security. You have to have been continuously physically present in the country based on the date that TPS was designated, and that's different for each country. The example that I gave you earlier was Haiti. Haiti was designated, I believe, January 21st of 2010, which means you have to have been continuously physically present in the U.S. since January 21st, 2010. And that's mostly for people who were in the U.S. prior to the earthquake in Haiti. And that's the key word. In most other countries, it would be the same. If something happened and DHS Secretary decided that country needed to be designated for TPS, they would set off a cutoff date. So anyone who entered after that date then would not be eligible for TPS. And there's a continuous residence requirement for TPS as well, and that's usually about 6 months after the designation date. Because at times, people may have been in a country for a certain period of time prior to the designation, but may have left for a temporary period for some reason. As long as you return by the continuous residence date, then you may still be eligible for TPS as well. Again, I'll go back to the Haiti example. The original designation was January of 2010, but the continuous residence date was July of 2010. So someone who had been here for, even if it was a year before the designation, and may have left because they had to go to a funeral or visit a family member, as long as they got back before the continuous residence date, they would also still be eligible for TPS. And I believe that date was July 21st of 2010 for Haitians. But for the most part, anyone who's eligible for TPS now actually already has it. Because when TPS is designated and it's announced, they give you a deadline to apply. And if you don't apply by the deadline, it's really hard after that to try and get TPS based on that. And of course, there's a requirement that you don't have one felony or 2 or more misdemeanors in order for you to be eligible for TPS. I've seen cases where someone may have been granted TPS, but upon further review, it's determined that, hey, you have 2 misdemeanors or you have a felony, you shouldn't have been granted TPS. I've seen that happen as well. Or if you get TPS and after being granted TPS, you end up being convicted of 2 or more misdemeanors or a felony, then TPS can be revoked by USCIS as well. We'll go to the next one. Now, these are the countries that are currently designated for TPS at the top. Like I said before, there are about 10 of them. The oldest designation of TPS is for Honduras. That happened in 2009 following a really, really terrible earthquake. Same thing for Nicaragua. Not an earthquake, but I believe it was a hurricane.
In 1999.
1999, right? That was the oldest Honduras. Which hurricane?
Hurricane Mitch.
Mitch. Okay, I wouldn't remember that. I was too young for that. But El Salvador, about 2001, and some of the more recent ones, Syria, Yemen, and those are because of civil strife in the country, is why they were designated for TPS. You'll notice Haiti up there, like I said, it was January 21st, 2010. That was the initial one. there was a redesignation of TPS for Haiti in 2011 because things got really bad after the earthquake, about a year after, because of a cholera outbreak that actually happened. And the DHS secretary at the time determined that Haiti needed to be redesignated for TPS because there were a large group of people that entered the U.S. after the earthquake, and they were unprotected, and they still couldn't go back. And there was a decision that was made to redesignate in 2011, which is why you see the 2011 date, because that was the most recent designation of TPS. Now, countries that have been previously designated for TPS who no longer have it, Liberia, Sierra Leone, like I said before, the Homeland Security Secretary can determine when TPS should end, and they decided for those countries that TPS, well, the nationals of those countries could actually go back to their country, so therefore TPS was ended. A few of those countries right now, they're currently designated for TPS, but the announcement has already been made that TPS will end for them as well, even though currently they're designated. I believe most of them, 2019, are the upcoming termination dates for those countries. What's the next one? The second thing that we want to talk a little bit about today is deferred action. This is something that's not in the statute or in the regulations anywhere, but it's a decision that was made by then President Obama back in June 15th of 2012 to offer some protection to people who enter the U.S. as children. And it's just deferring action in their case. Deferring action means we understand that you're in the country unlawfully. We can pursue you if we want to, but we're deciding to defer action in your case, and we're not going to pursue it. And if action is actually deferred in your case when you apply for DACA, and if you are in fact eligible for it, you get things like a work permit, and you are able to remain in the country for a temporary period as well, similar to TPS. DACA, the guidelines, the requirements for DACA are a little bit different in that it doesn't matter what country you're from, whereas TPS does. In order for you to be eligible for TPS, you have to be a citizen or national of that country that was designated for TPS. However, DACA, you can be from whatever country that you're from. The only requirement that they say that you need to meet is that you had to have been in the country prior to June 15th of 2007, which was 5 years prior to the president designating, well, the president signing the executive order putting DACA into place. And it says that you have to have been here when you were a child meaning prior to the age of 16. You had to have entered the country and be undocumented at the time, as long as you were under the age of 16. And there was a requirement that you cannot be older than 31 when the executive order was signed. There was a second DACA executive order that was signed. However, there's been some lawsuits about it, and they determined that the president went too far with the second DACA. I think it may still be in the courts right now, that second DACA issue, where actually they started something with DACA and DAPA, which would be for parents of U.S. citizens that are in the country. But right now, the current DACA requirements are that you're under the age of 31 as of June 15, 2012, came to the U.S. prior to reaching your 16th birthday, and continuously resided in the U.S. Since June 15th of 2007. Now, the popular misconception about DACA is that it's a lawful status. It's not. DACA is just deferred action. It doesn't grant you any status like TPS grants you status. TPS, while you're in TPS, you're in the country unlawfully. While you're on DACA, they just deferred action in your case, but you're still, in fact, removable from the U.S. And similar to TPS as well, there's a requirement that you cannot have you cannot have felonies, and you cannot have what they call significant misdemeanors or 3 or more misdemeanors. The issue of significant misdemeanor is something that's been debated. What's a significant misdemeanor and what's not? And I think lawyers make arguments about what they consider significant misdemeanors, but USCIS has a running list of what they consider to be significant misdemeanors, and that's something that you can look at to determine if someone is in fact eligible for DACA. And the big thing about DACA is that there's a requirement that you have actually graduated high school or currently in school at the time that you apply for DACA. You don't have to have had, a college degree. You don't actually have to have your high school diploma, but at least you're in school, in accredited school that's recognized by USCIS, you can actually show that as proof that you are in fact eligible to apply for DACA. And similar to TPS, DACA provides you an opportunity to work in the U.S. Work permits are granted for a period of 2 years, and they are in fact renewable. So after applying for the initial DACA, if your DACA is approved, you're granted a work permit for a period of up to 2 years, and usually about 4 months prior to the expiration of DACA, or of your DACA status, you can actually apply to renew it if you continue to meet the requirements for DACA. Now, things have changed a little bit, and I think that's why we're actually here, is because, in my opinion, there's an attack on some of these humanitarian relief that was available to a lot of people. For example, I believe recently President Trump decided to terminate DACA because he decided that it was unconstitutional for President Obama to actually sign that executive order in the first place. And that's still being litigated. It's still being debated. We never know what can happen, but I believe right now there's an order in place saying that anyone who had DACA before can continue to apply for it and can continue to renew it, even though the president actually wants to terminate it. Now, no one can actually apply for DACA for the first time because of what President Trump did. However, if you had it before, you can continue to renew your status. And same thing with TPS. The president decided to end TPS for a lot of countries. I believe of the 10 countries that I had up there, I want to say at least 6 of them have been terminated. So a lot of people, I think DACA, there's about 800,000 people on DACA status. So if DACA ends for those people, imagine what will happen to them, what's next for them. And I think that's why we're here, to determine what can we do moving forward once DACA status ends, and what can we do moving forward for the couple million people that are currently on TPS once their TPS status ends. And I encourage everyone, if you can, take a case, look into a case for someone, see if there are options, because there are, in fact, options for people. Just because DACA ends, that doesn't mean it's all over for them. At times, they may have a family member that may be able to petition for them. They may have been a victim of a crime and then be able to apply for a U visa. They may have been married to a U.S. citizen or permanent resident and been a victim of domestic violence. They may be able to get something called a VAWA. So there are potential options for them. They just need someone who knows what they're doing to be able to work them through it, and which is why we're here today. That's it.
Great. Thank you so much for that. Before we actually get into the discussions of what other reliefs are available, we still have a couple of minutes, so I think I'm going to ask some clarifying questions just to make sure that everyone understands on the same page. So if you were to explain to a 5-year-old, right, when it comes to whether someone has legal status or not, what is the difference between TPS and DACA?
Okay. DACA, like I said before, it's deferring action. It's in the name, deferred action. It's not according you anything. It's not affording you anything. They understand that you're in the country unlawfully, but the government is exercising their discretion to defer action in your removal case. That doesn't grant you a status. It allows you to remain in the country for a temporary period, but at any point that can be overturned. They can start that process back up against you. The difference with TPS, if your country is designated for TPS and you are granted TPS status, you're protected from removal for that period of time. You actually have a lawful status when you have TPS. It's a status that's granted to you. It's not an action that's being deferred. It's a status that was actually granted to you for a temporary period, usually 18 months, but can be as little as 12 or 6 months.
Perfect. Yes, question?
So if you are here unlawfully and then granted TPS, does it cure your original unlawful entry or overstay?
That is an excellent question. A very astute question as well. I would think that you're an immigration attorney. No? Okay.
I dabble.
All right. The short answer is no, it does not cure your previous unlawful presence. That's the short answer. However, there are ways around that, and I've had a few cases where I've actually argued it. And I even think maybe the Ninth Circuit? Sixth Circuit. Sixth and Ninth Circuit. Where they've actually ruled on that issue, saying that the grant of TPS actually cures your previous unlawful presence, or that it's an admission, right?
But we'll get into that also.
Right. It's a little different. It's a little different in the 11th Circuit. Section. However, you will run into issues of either ICE here in Miami saying that it doesn't cure the previous unlawful presence. But I have, in certain cases, found ways around not necessarily curing the unlawful presence, but getting someone to be able to adjust their status to that of a lawful permanent resident based on the fact that they have TPS by doing some interesting legal things.
So you said in your presentation that if you currently don't have TPS, then you're probably not eligible for it. That's the general rule. So what do you do when someone comes into your office and they had TPS before, and for some reason or another they lost it, either because they didn't have the money to renew, or they were in the hospital, or et cetera, and they're looking maybe to do a late re-registration, or they're looking to do an initial late registration? Can you talk a little bit about that?
Absolutely. I want to clarify one thing. If you don't have TPS now, it doesn't mean that you're not eligible for it. You may meet all the eligibility requirements. However, you didn't apply in time, and part of the TPS, well, not the regulations, but when TPS is designated, it tells you that you have a very specific deadline by which to apply. And of course, whenever you have a rule, at times there are exceptions. There is such a thing as late registration or late re-registration for TPS. And actually, I believe ATFR 244 has specific instances where an applicant can do a late registration and a late initial registration and a late re-registration. They are in the statute. You can look them up. It's a case-by-case basis. They have very specific instances where you can actually do that, so you should look into it. Now, the person may be eligible for TPS because they meet all the requirements, but they have an issue with not filing by the deadline. Don't just say, hey, you didn't file by the deadline. Yeah, it's over for you. You actually have to look into it to make sure that they don't meet one of the exceptions that's outlined in the statute.
Thank you. I believe we had a question.
Do you know how, for both programs, do you know how it's treated if you have a client who's under either one and they have a misdemeanor or a low-level felony, but they get a withholding adjudication? Is that recognized, or is it treated the same as a conviction?
Good question. And in immigration law, a withhold is the same as a conviction. It's short and sweet.
You had a question in the back?
I have a question. You mentioned that, like, for people from Haiti and Honduras and El Salvador, that their TPS is supposed to be out probably in 2019?
Coming next year.
Around that time?
Correct.
So if, let's say, you have a case and you have someone who, okay, they're on TPS and 2019 rolls around, and let's say they have a petition from a family member, or they have something in the works, but it's not settled yet, whether or not they're going to be granted this petition, whether they're going to get their lawful permanent status or whatever. Do they get to stay, or do they have to leave?
It's a good question. When an applicant applies to renew their TPS, especially when TPS has already been terminated, on the letter that you receive saying they received your application, it tells you specifically TPS is ending on this date and you have to make arrangements to leave. Now, if the applicant doesn't actually leave, I think you can imagine they're in the country unlawfully. There are certain petitions that you file for a person. It does not entitle them to remain in the country. It's just a petition. Let's say I'm married and I petition for my wife. That petition by itself does not entitle my wife to remain in the U.S. It's just a petition to determine if my relationship with her or him is a legitimate or a bona fide relationship, and that's all. There are certain applications, like an application to adjust your status, that entitles you to remain in the country while the application is pending. That's a little bit different. So if you're in that situation, the applicant wouldn't actually have to leave the country once TPS expires. But if you don't have an application pending that actually entitles you to remain in the country, then client would have to make a decision on whether or not they want to remain, which they would remain unlawfully, or if they want to go back.
Did they do away with any, like, domestic violence, anything?
Do away with it? It's still around, and I think one of our speakers is going to be talking about DV type cases a little later, but it's still around. I think you're maybe speaking about VAWA, the Violence Against Women Act, but that's still, that's still, in regards to asylum, but that's still intact. But AB is a recent case that came out that talks about when a victim of domestic violence can actually be granted asylum. But we'll be talking about that a little bit later.
So before we move on to the next section, which is going to be relief that you can get through family petitions, I just had one last question for Peterson. Is TPS and DACA really over? Is it really, really over? Or is there a chance that it may be redesignated, or it may be extended depending on where the administration is a year from now, or where politically we stand a year from now? And the reason I'm asking is just to clarify, because TPS is something that's in the INA, which is the law. So it's not that they're getting rid of TPS, but the way that they enforce it or they grant it is up to their discretion. And with DACA, with all of the litigation, I just want to make sure that we at least put it out there, the hope that will it possibly be extended, and has it been, for example, for Haiti, they said that it was over, and they gave us 6 months, and then they redesignated again.
Right.
So is there a slight hope or a slight chance that possibly in 2019 the law may change, or the expectations of TPS holders may change?
I say there's always a chance. You never know. But I think it's important to make sure you understand TPS as a whole is not going away. It's in the statute, and it's here to stay. Now, whether or not the administration wants to designate a specific country for TPS, that's something completely different. However, you never know. Tomorrow, God forbid, something can happen again in Haiti that would force the administration to redesignate Haiti for TPS. But for now, their position is that conditions have improved so much in the country that residents of that country can actually go back, or the country's in a position to reaccept their citizens from 7 years ago or from 8 years ago. Yes, there's a slight chance that they can change their minds, but I'm not optimistic, I guess you could say, because they did a review sometime last year. After that review, decided to extend for only 6 months. And then the second review decided, you know what, we're going to terminate, and we're giving you 18 months to either fix your status or prepare yourself to go back home. And that's where they're at this point. But TPS in general, it's not going anywhere. It's just the very specific countries that were designated for TPS. Those can actually be terminated, but there's always a chance.
In recent years, have there been any reference points in terms of countries that had the designation that was removed, and then people were returned to their home countries? I'm curious to understand what the process of actually, after the revocation of the status, to getting people back to their home country.
That's a great question. I think I showed earlier there are 3 countries where the status was actually, TPS was actually terminated for them. Those are smaller, not smaller countries, but smaller groups of people, so it didn't really make a lot of noise. And I think the first large group of people that we're going to see is going to be Haiti and Honduras. I think Haiti has about 60,000 people on TPS, and Honduras maybe 200,000. So we're actually that's going to make noise. We've never actually seen the actual process and how it works, because it's always been smaller countries where no one really made any noise about it. But if you have to return 200,000 people back to their country, you would imagine that's going to make a lot of noise. My bet would be that it's not actually going to be what we think. They're not going to be, rounding up people and saying, we're sending you back home. It's just a matter of once it terminates, if you come in contact with law enforcement, you no longer have a status, we're going to remove you. That's most likely how it's going to work, because I don't think DHS or ICE has the capacity to go round up 200,000 people at a time. I don't think it would actually work that way. It's just a matter of whenever you come in contact with law enforcement, if you have no status or nothing that entitles you to remain in the country, then they're going to use that as a reason to remove you.
But it would be the U.S. Incurring the cost and the time to deport people, essentially.
Yeah, absolutely. Because if it's going to be, because in order for them to actually remove you, they actually have to initiate removal proceedings against you. They can't just put you on a plane, or TPS is over, I'm putting you on a plane and sending you back. It doesn't work that way. So they actually have to initiate proceedings. And if they actually order you removed, a lot of the times you have an appeal period, 30 days, you file an appeal. Sometimes you can remain non-detained while the appeal is pending. Are they going to track you down? We don't know. If you're detained and you have a removal order that becomes final, then of course they bear the cost of actually removing you back to your country. Unless for some reason you apply for something called voluntary departure and you agree to leave on your own within a certain period of time. But most likely the United States will have to bear the cost of actually removing everyone.
So thank you so much for that. That was a lot of information.
Great job.
Our next speaker, Lodi Jean, will be focusing on family-based relief for folks that currently have TPS or DACA. Lodi Jean received her JD at St. Thomas University. From 2004 to 2012, she served with the state attorney in Miami-Dade County, first as assistant state attorney and then as felony division chief. She is the owner of Lodi Jean PA, specializing in immigration and criminal defense with a focus on deportation-related matters. Ms. Jean is the immediate past president of the Haitian Lawyers Association. During her term as president, she led HLA's response to the current administration's decision to rescind TPS for Haitians and partnered with the Haitian ambassador in DC to provide a hotline answering TPS-related questions for the Haitian community. She is also very active with the League of Prosecutors and serves with the UPL Committee for the Florida Bar.
Thank you. Can we go back a little bit to the slide? Sorry. the one that, because I'm going to piggyback a little bit off of what Peterson mentioned about the numbers and how people come into contact with ICE. Yeah, right there.
Okay, great.
So, you heard Peterson say that about 60,000 people initially registered for TPS from Haiti. If you add up all these numbers, and Adanya will correct me if I'm wrong, there's probably about 200,000 TPS recipients from all these 4 countries.
I think in total it's about 300,000.
Okay.
Yeah.
And El Salvador is the largest with over 100,000 or so. Mm-hmm. And I think you have about 700,000 DACA applicants. So if you add all of those together, you're talking about 1 million people, right? 1 million people. And if, as you saw about the vetting process, you can't have more than 2 misdemeanor convictions to have TPS. So you can only have 1. And what's a misdemeanor conviction? Driving with a suspended license, not having a valid driver's license. How many just regular Americans pick up those tickets that actually are criminal in nature all the time? And for DACA recipients, they can't even have, not that they can't even have a DUI because it's serious, but 1 DUI, you're out of luck. 1 felony conviction, you're out of luck. And they can't have more than 3 misdemeanor convictions. And so when they talk about extreme vetting, they really are vetted. And every year and a half, they have to get fingerprinted. And that's the classic way that people come into contact with law enforcement. When they get fingerprinted at the border, coming back in, at the port, on a cruise ship, when they ask for admission at a border, Texas border, right, between Mexico. And every time they renew any type of work employment authorization, things of that nature. And so if you think about the number of people that are generally non-criminals that are going to lose their status, what happens when they don't have a work authorization and they can't get a driver's license, and then they get stopped for that 1 ticket and the 2nd ticket, the 3rd ticket. So we think it'll be like a domino effect where you're creating this group of people that are non-criminals, and then perhaps you're making them criminals in a way. And I'll give you another set of numbers that, between the last administration and this administration, they've deported about 250,000 a year. That's the maximum. And generally these people are coming from the border or they're coming from our prisons, right? Because people that are non-criminals generally are not going to be placed in removal proceedings. And so when people say that you can't deport your way out of this situation, it's really based on the numbers. It's not random politicians grandstanding. If you can deport a maximum of about 250,000 a year, and you have 1 million that are non-criminals, that are not a priority, when are you going to get to them? Probably aren't, right? And if you even add the number of people that we think are in this country illegally, you know, the workers, the farm workers, mostly from Central America that cross our borders, that's about 20 million. So think about it. You can't deport more physically than 250,000 a year. You have at least 20 million that are here in this country illegally. What are you going to do? You know? And so, you know, there has been some talk in Congress about finding a fix for all of these people. And there's been a number of different congressional, you know, proposals to fix it. But yet we have nothing, you know, we've seen nothing done. And the Haitian Lawyers Association, through the ambassador, you know, we asked for TPS to be redesignated because we thought Haiti, of all the countries, between the earthquake in 2010, the cholera epidemic that Peterson mentioned, the Hurricane Matthew in 2016, and even Hurricane Maria skirted the North Coast. You know, we thought factually that was one of the countries that, you know, deserved to have the TPS designation. And there are some pending lawsuits, one of which we, the Haitian Lawyers Association, joined in with the NAACP's Legal Defense Fund, and that's still going on. And so, you know, when I see that DACA, you know, the lawsuit in DACA, that DACA recipients are allowed to renew their DACA applications, you know, it's promising, because that case was in front of one of the most conservative judges in Texas, Judge Hannon. And so, you know, if he's allowing for that renewal based on the way that the administration decided that they were going to terminate DACA, we think that we have a good chance of winning on the TPS arguments just based on the way that the administration decided that they were going to terminate TPS for all of these other countries. And so be on the lookout for that. But moving on to what I'm really here to talk about. Okay, so, you know, what do you do when you have someone that has DACA or TPS? How do you make them legal? How do you adjust their status? You know, what does adjustment of status means? You're going from one status, which is no status basically, to lawful permanent resident status. And so, you know, the classic way that we try to do that is through a family petition. And there is a difference between immediate relative and a preference category. You know, what is an immediate relative? The classic example is a spouse, right? Or an adult child, 21 or older, who's a U.S. citizen that now wants to petition for mom and dad. And it's not unusual to have someone who does have TPS, whose kids were born in this country, who are now older and can apply for mom and dad, okay? You know, the preference category is a category such as brothers and sisters, siblings, where there is a set number that is given out every year, and they are used up, you know, they're used up pretty quickly. And so you have to wait longer than if you were part of the immediate family category. And the State Department has all of this information, as does the USCIS website. And so you file the form I-130. You know, that's the classic family petition. But there are some things that you have to be on the lookout for, such as how this person entered, if they do have unlawful status, how long they've been here, if they have any other issues of inadmissibility, right? So even though they're in the country, they may be inadmissible to go from one category to another, and that's what we mean by inadmissibility. And, you know, I-601 versus I-601A, those are the forms that we can waive someone's inadmissibility. So someone that has TPS or DACA, they're probably inadmissible for having unlawful presence. You know, they may have entered here by crossing the border, some through a boat, and they've accrued either more than 180 days where they're out of status, or more than 180 days. And so in certain circumstances, you know, you may be able to file a waiver to waive that for them. We also have up here adjustment of status and consular processing. Some people are eligible to get their resident cards in America, and some have to go back to their home country and do consular processing. So the classic example is someone who has unlawful presence and needs to waive that unlawful presence. You know, we have a lot of TPS recipients that, I think the classic TPS recipient that we dealt with on the Haitian Lawyers Association is someone who's been here for, you know, 10, 15 years. They've been through the system, they've been in front of a judge, they lost their case in front of a judge, and they have a final order of deportation, right? But, they're now married to a U.S. citizen spouse. And, the question is, can that spouse give them a green card? Okay? So you file the I-130 and you get that approved. And as Peterson said, that doesn't give you a benefit. It just says the marriage is real. And in the future, you can get the green card, right? But, the hurdles that you have to overcome are, if they came in illegally, they've now accrued unlawful presence, they have that final order of deportation. What do you do with those two hurdles that they have in order to make them legal in the United States? Okay? So that's where the I-601A becomes handy. And it's not here, but you have a handout with I-212 on it. I'm not going to get too complicated, but you all just have to be aware that if someone wants to, like the classic situation where someone wants to get their resident card from a qualifying relative, such as a spouse, but they have unlawful presence, they've been in front of a judge, and they want to get that final order of deportation cleared up. Because what I always tell my clients is, generally speaking, if you've already been in front of a judge, you got to clean up that case. You got to take care of that. Right? So how do you take care of that? And Melissa's going to go into this some more. But, and she's going to get into how you can actually reopen that case in front of the judge, right? But if that judge doesn't want to do that, there is a way to waive, okay, that final order of deportation, and that's where the I-212 form comes into place. And I just printed out the case because it gives you 10 factors that you must present to USCIS when you're asking for that application of relief, right? And that qualifying relative, the spouse, has to suffer extreme hardship if they want to. You have to prove that they're going to suffer extreme hardship from that separation. And that's where that other handout that I brought also comes in handy, because it talks about 14 factors and it defines what extreme hardship is. And I just find that comes in handy when I'm filing for these types of relief. Okay? But one of the first things you're going to do at your intake is you're going to find out, how did this person enter? Have they ever been in front of a judge? Who are the qualifying relatives? Do they have the unlawful presence? Okay? And then once you get that basic information, one of our slides also discussed FOIA, Freedom of Information Act. It's very important because some people don't even remember their own history. Because again, even though some TPS, like for Haiti, it was designated in 2010, it doesn't just limit people that were here right before 2010, right before the earthquake. Some people have been here for 20 years beforehand. And you never know, some other relative could have applied for relief for them, another I-130, or some other type of petition, right? And so you want to know exactly what's in that person's file. You want to know if someone else had applied for something for them before, and that's where 245I becomes important, because the laws, Congress has changed the laws in the past. And so, I want you guys, if you're curious, just Google 245I, and it has a definition of how, if someone had a family petition or some other immigrant petition filed on their behalf, if it was filed before April 30th, 2001, they are protected under the old law. And under certain circumstances, you can apply for an adjustment of status for them if they had that application filed, if it was approved, or if it was approvable at the time, okay? But they may not have that 2001 application handy for you to see, but it should be in their USCIS file. It should be in the FOIA file when you order it for them, okay? And so, once you assess all of that, then you can sort of gauge if that person can either get their resident card in the U.S., or if you have to file all the various forms so that they can then get their status adjusted in their home country. And let me know if this is going over. No? Is it? Okay, I'm sorry. I mean, what you have to understand is, some people can get their residence cards in the U.S., and some have to do consular processing. And there's a number of factors that you have to take into consideration. How did they enter? What immediate family member or other relative can apply for them to adjust? You should always start out with having their their immigration file. And the FOIA will allow you to order it from USCIS, which is where someone applies for Freedom of Information Act, where someone applies for, USCIS is just the basic, green card application, old, work permit applications, things of that nature. And then you could also order their FOIA from EOIR, Executive Office of Immigration Review, which is the courts, right? Which is the court. So if someone has ever been in front of an immigration judge, you should be able to have a copy. With their permission, you can obtain a copy of their file from the courts. So you could see exactly, if they have an entry record for them, things of that nature. If they have a final order of deportation, right? So, that's why the FOIAs are very, very important. And then once you go through your checklist of their history and who is going to be able to apply for them for relief in the future, then you have options of the I-601As and the 245Is. Okay? Yes?
Question. If they have to do the consular processing, right, which means they have to go back to their country, they're not able to come back without that process being finalized?
Generally speaking, no. There are some people that are able to apply for a travel document, which allows them entry back into the United States. And that's gotten harder and harder to obtain from DACA and TPS recipients. In the past, when the programs were first instituted, go ahead. Sorry.
Oh, I was just going to say, the litigation that happened around DACA has specifically said right now you can't apply for advanced parole if you have DACA. Advanced parole for TPS still exists. We're still applying for it. And the benefit of traveling under advanced parole is it gives you that lawful admission, which may give you the avenue to adjust status here in the United States without having to do the consular processing. As attorneys, and I think everyone kind of takes a different perspective as far as who you're going to apply for advanced parole on. I'm a little nervous with people that have deportation orders. I know people have traveled under advanced parole when they have a final order of deportation.
I don't know that term. What is that?
That's the travel document. So the travel document that you apply to USCIS in order to get permission to leave and re-enter. The thing is that you need to note about that is it's not a guarantee. You're being inspected when you're entering, if you're at the airport and presenting in front of CBP, Customs and Border Protection, you're seeking admission. And even though you have this document that says that you're allowed to enter back in, theoretically, CBP could deny that entry if there's any criminal convictions that would make you inadmissible. And even with deportation orders, sometimes I know a lot of people do it, but I always get a little bit nervous. I don't want to be that attorney that says, yeah, you're going to be fine, and then they don't get back in.
So maybe to clarify some questions, let's take a couple steps back. What are the requirements for you to adjust status, which means you're physically in the United States and you will receive your green card in the United States? What are the specific requirements for adjustment of status?
Okay, so it's your burden to prove how you entered, and it's your burden to prove that you have that relationship with the person who's applying for you. If it's an older application, some people have I forget not the work petitions. What do we call it? Labor certifications. Yeah. So it's your burden to prove that you qualify and you have that visa category and that visa number available to you.
And do you have to have entered legally to qualify for adjustment of status?
Generally speaking, yes. And that's where the advanced parole that Adanya was talking about can become useful in the future because there are some people that don't have that initial legal entry, or maybe they can't prove it. We've come into contact with some older adults that they know someone brought them in through the airport with a passport, but they lost that passport. So even though they remember that they came in legally, if they can't prove it, USCIS can also deny that element of their application. And so, if someone has the advanced parole, they leave and they come back in, that's considered a lawful entry. And so
I think, sorry, because I know we're using a lot of terms, so just to bring it back a little bit, is getting on an airplane with a valid tourist visa, landing, going through CBP, getting a stamp on your passport, is that the only legal way of entering into the United States so that you're eligible for adjustment of status? Besides
the advanced parole that we talked about?
Right.
Yes.
So you have to be admitted with your visa, or you have to be paroled in. So you have to show that you were either stamped in, right, with a regular visa, or you were paroled in, which means that once you get to the border, immigration made the decision to legally let you enter, and they paroled you into the United States. If you have a parole, and not all paroles, I mean, this is a little out of scope, but most paroles will get you to be eligible for adjustment of status. You just have to go into the statute and see which ones don't. But for the most part, if you're let in with parole under humanitarian circumstances, you're able to continue and adjust status as if you came in with a visa. And what happens if you're here unlawfully? Do you have, you came in with, on a ship, no one caught you, you've been here for 10 years. Now, so you're physically here, but you're not legally here. You did not legally enter. You weren't admitted. You weren't paroled. Can that person file for admission? Do like a parole in place, or?
The paroles in place that I've dealt with are for when you're a spouse of a military person. And so, there are avenues where you can ask USCIS to give you a parole, which would then be the legal entry you need to prove to get that resident card application. And so there are limited applications for that, but the only one that I've dealt with is the military, the parole in place for the military spouse. So if you have a spouse who's a military person and that person's a U.S. citizen, you can benefit from having that relationship and ask USCIS for the parole entry.
And one reason, when it comes to TPS, the reason that we're spending so much time talking about the difference between being legally admitted versus not having a legal entry versus parole is because TPS may allow you to create an opportunity, if you came in unlawfully, to leave on advanced parole, which is the travel document, and if you're allowed to come back in legally, then you're legally admitted and stamped, then you're able to adjust status.
And going back to Ms. Levine's question, when you were going back and forth to Peterson regarding the different circuits, in the 6th and the 9th Circuit, the grant of TPS is considered an admission. And so therefore, if someone had entered illegally in those circuits, you can then apply for an adjustment of status. And so, that's just another little quirk in the different circuits. Yes.
Oh, go ahead. Yeah, I have a question. If someone comes in illegally at the border and they get stopped and they lie to the federal officer
about
who they came in with.
Okay.
So they came in with someone else's passport, for example.
Let's say that let's say that a teenager came in with an adult. A coyote brought them through. And the teenager was told that if they get caught, he has to say that he's the adult's child. And that happens. So is that lying to the federal agents?
I think one of our speakers is going to get into human trafficking.
Okay.
And if there's relief for someone in that circumstance, because it sounds almost like duress, what you're describing. They're a minor at the time. They're being instructed what to do. They're being directed. And so, there are different reliefs for people that are considered victims of crimes. Okay.
And there are circumstances, for example, if immigration finds that you've committed immigration fraud,
right?
And a common example is when you come in with using someone else's passport.
Okay.
You can apply for a fraud waiver when you file your green card application.
And it still counts as an admission, you just need that waiver.
Right. So you're lawfully admitted even though you committed fraud. The only caveat is you're not able to use a passport of a U.S. citizen.
Right.
Because if you, as an immigrant, if you ever claim to be a U.S. citizen, then you're just barred from most immigration relief. A question in the back?
Piggybacking into your FOIA and how important it is to look into what they have. So is it a rebuttable presumption that, let's say a file says you came in illegally, like can the person that applies rebut that and I guess, prove that they came in legally, or is it, like, whose burden is it?
Well, it's your burden to prove that you qualify for what the relief that you're applying for.
So the person applying has to show that they came in legally.
Right, and go ahead.
So an example, and we recently had a DACA case like this, the client was waved through the border. Like, so a lot of times, particularly a while back, you're in a car with a bunch of people, you're going through the border, and they just wave you through. That is an admission, but you really don't have the evidence of it. And there's a board case that goes into, you know, how you establish that and meet that through whether it's affidavits or declarations, but that can still count as a lawful admission. So really knowing somebody's history, and a lot of times they say I came in without permission, but then you actually delve in and talk to them a little bit more, and then you find out, well, you came in a car, you were waved through the border.
So is an evidentiary hearing had on the issue generally, or no? Okay, so it's actually.
So for the most part, you're dealing with a USCIS officer.
Got it.
And that's really important to keep in mind because the way that you're preparing your packets, the way that you're presenting the information, the way that you're arguing your case, you really have to understand that you're not in front of a judge when you're dealing with USCIS. You're not in front of an attorney. So you really want to be mindful of that while you're representing your client.
So if you can't prove that legal entry, that's where the I-601A becomes important and useful as a tool. I mean, the big hiccup is, if you can't prove your legal entry, you may have to go back into consular processing, right? And so a lot of people are afraid to leave, but this was, this was a process that the Obama administration created, recognizing that there are a lot of people that either entered illegally with the unlawful presence, and they could start the process here instead of leaving and doing everything at the consulate. They could start the process here, get an answer as to whether or not the waiver is going to be granted, and once the interview is available for them, they leave. They leave and they finish the process for the adjustment of status at the consulate. Okay. But remember, they need the qualifying relative, that's a spouse or a parent, to waive the unlawful presence, and that's where the extreme hardship and that handout becomes useful because it gives you a list of what under the regulations is considered extreme hardship for you to prove for your family member to get that waiver approved. Yes?
I don't know if this is specifically because I deal with children, but I've had some cases where I've been able to get visitor visas for folks to come in by explaining that they have a means to lawful entry and to adjust status, and therefore they don't have intent to overstay a visitor visa, that they have full intent to go back to the country to finish the process. Is that ever an option? I don't know if it's just because it's children that I'm dealing with that this works in an adoption context.
And they have either a petition approved or pending?
They have pending petitions that are a means to a lawful entry and adoption. And even in Haiti, I've had immigration officers grant visitor visas for the families to leave and be reunited in the United States while they wait for that long process to happen, by explaining that that the intent is lawful. It is just for a visitor visa because they have all intent to come back and finish the process.
Well, I mean, I think that's what's key, right? You've shown enough intent that they are not going to overstay and violate the initial entry, and that they're going to go back and finish the process.
But those other folks that have another means through marriage or qualifying relative, could they not make that same argument?
So that's a little bit outside the scope, I think, of today's conversation, because you're getting into, which is interesting, but you're getting into folks that are overseas and trying to get them tourist visas to be able to come in and out to be reunited with their families.
Well, I was asking if you could apply that when somebody would voluntarily depart, while they have part of the process going to adjust status that was filed here. Now they're back in country. Could they get a visitor visa to come back?
It's possible if they file for a waiver. The 212
Yeah. I'm not going to take any more time, but VAWA, Violence Against Women Act, it's not only limited to women, it's also another avenue of adjusting your status. Think of the VAWA, which is filed on a Form I-360, replacing the I-130, right? It's an immigrant visa petition that's available to you. It does lead to adjustment of status. There's also other benefits regarding public benefits that are available to people regarding children that are able to benefit from it. The one thing that I wish I had learned early on in the VAWA is you don't have to divorce. The spouse doesn't have to divorce the person that's subjecting them to the cruelty. You could qualify for the VAWA even if the marriage is still intact. The one issue that I know a lot of practitioners get frustrated with, it takes a lot of time for it to finally be approved. And so, so you have this limbo period where, you don't know, your status is not yet settled until the VAWA is approved. And then once it's approved, then you can apply for the adjustment of status. So that's also another way of gaining residency if you don't otherwise have status, such as TPS recipients or DACA recipients. Okay. Thank you.
Thank you.
I wanted to go back to the question that came from over there, I think, about the child lying to the official. There's one thing I don't think we should skip over because I think it's important.
Sure.
Of course, it's always bad to lie to a federal officer, right? However, in order for immigration purposes, for that lie to actually affect you, it must be a material misrepresentation, material to the benefit that you're seeking. So I think in your question is, okay, yes, the child saying this is my father or this is my uncle, how is that material to her being admissible to the U.S.? So if you're getting pushback on that, saying that the client committed a misrepresentation, you should push back as well and say that misrepresentation should only affect a child if it was material to what the child was seeking. And if it wasn't material, even if it was a lie, if it wasn't material to what he or she was seeking, it should not have immigration consequences. I think it's important for us to understand that. Yes.
And when you say seeking, does that mean seeking in regards to a waiver or a status, or seeking as to, in that moment, entry?
Either way, right? In that very situation, I assume that the child was looking to be admitted into the U.S. Okay? So in that situation, it's entry. In another situation, while applying for a green card, that's seeking a benefit. If she lies about her birthday, well, birthday is a bad example. Yeah. But if she lies about whether or not her mother or her father is alive, if that's not material to the application, yes, it's a lie, but it should not be a lie that affect her or prevent her from getting the adjustment of status if that's what she's seeking. In that instance, if her being with or without a parent doesn't affect or it's not material to her being admissible or not, then it should not have any consequences for her. So, I think immigration will try and get away with it and say, yes, you are inadmissible for misrepresentation, but attorneys should always push back on that designation and say, it may have been a misrepresentation, but it wasn't a material misrepresentation, therefore it should not have the consequences that you're trying to use it for.
Thank you. So our next section is probably the most difficult section. So thank you, Melissa, for taking that on. Melissa Pena, she's going to be speaking about different relief that you can find if your client is in immigration court. So far we've been talking about options that they have outside of court through family members, and now we're moving into someone actually in removal proceedings and what you're able to file for them to be able to remain here lawfully. So Melissa Pena, she's a founding partner of Darbath Pena Law Group, an immigration and family practice. Her life's work has been to help those that are faced with same daunting challenges that her and her family faced as immigrants. Melissa graduated from FIU undergrad and law school. While securing her own citizenship and studying law at FIU, she interned at Catholic Charities Legal Services, and she worked as a Florida Bar Public Service Fellow. She's currently the co-chair of the DCBA Immigration Committee, and she's also been recognized as a New Leaders Council Fellow in 2017 and has been a rising star on Super Lawyers 2016, 2017, 2018, and counting. So, Melissa?
How many litigators do we have in the room? I'm so excited. See, this is what I needed to see right here. The people actually were looking forward to going into immigration court and arguing these cases. Everybody here is super qualified. This is very dense. You guys, if you need, I need to clarify something, you feel you need to speak up, I would really appreciate the help. Because there's a lot that we're going to try to cover in a small period of time. Towards the end, we have some slides with recent case law that is very interesting, especially for some people that want to read into how fast-paced it is currently in immigration court and how we are actually litigating some of these cases. We may not have the time to cover those in depth, so we put the case law there for whoever wants to read it. If the time permits, we'll go ahead and cover a little bit of those. I know there was a question regarding BAWA and some case law because Christy pointed out it's one of the ones that's probably going to end up being in the slide AB. So the first thing that we're going to consider is some of that general relief in court. Some of it goes hand in hand. There are some of them it's also affirmative relief that it also could be used defensively. So the first thing that we're going to talk about is asylum and humanitarian asylum. For an alien to be able to apply for asylum, they have to obviously physically be in the country, and they're also unable or unwilling to go back to their own country based on the past persecution they have suffered and the well-founded fear of future persecution. Okay, and for this to for them to be able to establish this, it has to be based on one of the 5 protected grounds, which is either race, religion, nationality, political opinion, or membership in a particular social group. Usually when a person comes to the U.S. and they are applying for asylum, they have to do it within the first year of arriving, okay? There are exceptions to that. But if the person does not meet one of the exceptions and they are defending in court, this will be considered at withholding only proceedings. There's a difference between asylum and withholding. They're very similar. When one is pled, the other one needs to be pled. They're within the same form, but they have different burdens and they have different benefits. Withholding, what that means, it's very similar to your DACA right now, or a variation of the DACA/TPS, which means you are here, we're currently not going to remove you, we're going to give you a work benefit, a work permit, but this is something that could change at any point in time. You're going to go maybe once a month or in an order of supervision, and they're going to continue to review if anything had changed in their country. Even though this is now through ICE, they could try to refer it back to court to have the judge determine whether there has been something that has changed, and now they could send you back. So that is how they will be able to end that. So if we feel that somebody is eligible for asylum, you should always push for the asylum. The exemptions are very important for us to consider, because one of them is what Patricia was speaking about earlier, which is TPS. There's 6 of them. One of them is if the person has been a victim of violent harm during the time of that year, aside from the past persecution they suffer. The harm that they suffered during that year, that would have been an impediment for them to file within the year deadline. In addition to that, the second one is legal disability. If you have somebody who's a minor or who has a mental impairment, obviously they would have not been able to meet that deadline. Ineffective assistance of counsel, which I feel everybody here is somewhat familiar with. There are particular requirements within the regulation if you are going to use this as your basis to show why you did not meet the deadline. Number 4 is the applicant maintain a TPS status, lawful immigrant or non-immigrant status, or were given parole until a reasonable time before the filing of the asylum application. So if somebody actually had a status, and we have people that already came within the time and always has status, or people that were given status when they were minors, they did not accrue the unlawful presence. So we have more than one way there, or what could have been an impediment on the adjustment side and also on the defense side for asylum. Because if they didn't accrue it and they had another lawful status, they will be able to apply. An applicant who filed within the year, but somehow, somewhere had a rejected application. The application was not sufficient, it was not signed. There are different reasons why they will return the application to you. If it was corrected and resubmitted within a reasonable time, then they will go ahead and consider that an exception. And the death of serious illness or incapacity of the representative of the person applying or a close family member. For reasonable time, it's mentioned twice. reasonable time is not actually something that has been really defined. So this is going to be a case by case, and this is the time where they're going to look at what was the reason why this might have potentially been sent back. And we're talking sent back because maybe your deadline was an affirmative application that then later on turned into something that was referred to court and now we're on defense. So some of the stuff, because they have a comparable relief affirmatively and then defensively, may overlap, and then it may change what you have to prove. And as we were discussing before, some of this is going to be a lot of written argument to even see if you're eligible before we even get to talk about the facts of the case. Let's see. Another thing that we're going to see potentially issues in court about asylum application is going to be motions to pre-termit from DHS. A motion to pre-termit is a motion to disregard your application if they may be challenging your eligibility based on what they are considering to be a firm resettlement. And a firm resettlement means that you have been in another country that could potentially have given you this refuge that you're asking the United States government to give you. So, and for example, we have a lot of Haitian nationals who have actually and were successful going to Brazil, where may have been there for a few years. Some might have even had work permits, and then when they come and they want to be able to apply now for asylum, they are saying, don't even review their application because we have proof that they lived somewhere else for 3 years and they didn't apply for refuge there. So this is a little bit of a pushback. So really talking to your clients and being able to dig in, because we also have people that maybe they had they're Haitian nationals that also have a Bahamian family, and they were in the Bahamas. How long were you there? Or people that when they cross in the border, how long did it really take you? How long were you in Central America? It depends where you're from. How long were you in the other country, to see if you may end up having to face or argue a firm settlement issue. Another issue that we will face applying for asylum, it's a safe third country. There's a lot of people that have dual nationality, and we don't really think about it that much because they've never been, and they don't think about mentioning it. But if the government does know about it, the government is going to use that as, showing why is it that they probably wouldn't be able to qualify. Because if there is another country, whether you've been there or not, that you hold nationality and they will be willing to take you, they say, why don't you ask them for refuge instead of asking us? So those will be like the issues that we will be facing in court at the time of trying to apply for asylum. Humanitarian asylum. So humanitarian asylum we still have to prove the same component of asylum, which is the past persecution. So the suffering of the past persecution is something that still has to be established, but you don't necessarily have to prove the well-founded fear in the future to have a humanitarian parole granted. Okay? These are usually for very severe, inhumane cases. So it's arising out of the severity of the past persecution and the reasonable possibility of other serious harm that could happen to the person. So we're talking about somebody like a woman in Liberia who suffered genital mutilation, who was sexually abused and assaulted, who will continue to forever suffer the consequences of that type of past persecution. That will be, that in the general scheme of things and looking at all the facts, will be granted that. Other serious harm, in addition to the past persecution, does not have to be related to the past persecution, and it does not even have to be part of those 5 protected grounds. So it has to be something that would just be inhumane. It's past persecution plus inhumane. It's a simpler way of seeing it. Let's say right now we have a young person who is an activist in Venezuela who has been protesting the government, and they prove their past persecution, but in addition to that, they probably have HIV, AIDS, and they're unable to now, in the future, if they were to be sent back, to get their medication. So they're going to consider the fact that they established the first part and the potential of that very serious harm later on in order to be able to see if the person could get humanitarian asylum. Cancellation of removal. We have 2 different kinds of cancellation of removal. We're going to be talking about more about the non-LPR because this carries on from the DACA and TPS recipients, but there's two kinds. One is for somebody who is already a lawful permanent resident and somebody who is not a lawful permanent resident. So the interesting thing about cancellation of removal is even somebody that might not ever practice immigration has heard of, oh, I lived here 10 years, so I'm probably just going to get my papers because I haven't gotten into much trouble and I've been here for a long time, which is not necessarily the case. People have that misconception because they heard this before or because a long time ago they felt like it was easier. They don't know enough about it. Oh, my friend told me that they've been here 10 years and they own a house, so now I have that. 10 years is one of many requirements. This is a defense only available in immigration court. So this is one of the applications that does not have an alternative affirmative application for it. Okay, and was the reason why we need to emphasize that is because some people may feel like they meet their eligibility requirements. And I do definitely, I'm pro trying to be creative as to how to help our clients, but we need to be very careful of trying to put somebody in court that shouldn't be in removal. Even if they feel like they may qualify, it might not be the time to really move in that direction. So the requirements for cancellation are 10 years of continuous presence or more in the United States, good moral character, which is in the statute about what they will be considered to be a person of good moral character, no conviction of certain crimes, emphasizing the aggravated felonies, but obviously minor crimes, a combination of will actually disqualify you, and the removal will be an exceptional hardship to a qualifying relative. We already spoke about what a qualifying relative as far as that USC spouse, parent, or child, and that the person deserves a favorable exercise of discretion. So, for a cancellation or for what would have been a strong cancellation case, it's somebody that crossed the border, been here 15 years, had a TIN number, paid taxes, married to a U.S. citizen with 2 kids. One of them may have somewhat of an illness that the parent attends to, and they only had a driving without a license. So when they look at all the factors, the adverse factors and the positive factors overall, they will feel like a grant of the cancellation will probably be the best way to go. VAWA cancellation, Lori already spoke about what VAWA is, which is based on the battery of a U.S. citizen spouse or a lawful permanent resident spouse. What's more important about highlighting a little bit on the defense side is the defense side has a distinction as far as continuous presence. When you do an affirmative application within a month or 2 months of the actual assault or the abuse happening, the person who have the affirmative defense. And it's a little bit different when you are in the removal side. You are required to have continuous presence of 3 years prior to and good moral character 3 years prior to. We're going to talk a little bit about what continuous presence it's going to be and what people really need in order to be able to show that. So the same way that somebody had TPS and they had to show that they were here before a certain time, when they had DACA and they had to show that they were here at a certain time for cancellation or removal, you're also going to, and even to show your continuous presence for VAWA, you're going to have to show that you were here before a previous time. So this is when, obviously, people got to get creative. If it's somebody that has come up through the border, they're actually not going to have a legal entry. So, but they already created a life here. So medical records, school records, vaccinations, birth certificates, leases, receipts. It's important to know that affidavits help, and they're great to supplement, but they're not like the primary or secondary source of evidence. They actually want some kind of document. If you have government documents, they're obviously always better. So it's going to be a combination of things. Even things that are negative that people don't think about, like if you got a ticket or you got 6 tickets in the last 10 years, and we have a lot of driving without a license, people don't think that, but that would also help you try to put together chronologically your evidence. Okay. Prosecutorial discretion. So prosecutorial discretion is the power that DHS and ICE, I wrote that it had, but this is a little interesting, okay, to stop removal and exercises of discretion and deciding based on whether the case is high priority or not, whether they were going to move forward and prosecute, okay? There was an executive order signed by a current president in January of 2017 that muddy up the waters a little bit. Because first, at the beginning, it says that now everybody, it's a priority, but then later on starts developing again which ones are more priority than others. But because at the beginning it says everyone's a priority, it's a little confusing now for some of the agents as far as enforcing how much can they really work with us. In the past, we have moved with some of our motions, and either a motion to reopen or even motion for prosecutorial discretion, and showing all these equities that we were talking about for cancellation. I mean, this person has all these things. Maybe they will be qualifying soon. They have a U.S. citizen child that's 20 and a half. And if we could just push this forward, we'll be able to qualify for another form of relief. So you did a lot of that lawyering, and you worked with the government so that you necessarily didn't have to go do it in court. So now, because of the change in the enforcement, it has made it a little more difficult for us as practitioners to necessarily be able to request this. And it's not, we're not only talking about the CISA Chief Counsel, but we're also talking about ICE officers, because we're able to also post these things to them if the person already had a final order and now they're under ICE jurisdiction on DHS. Administrative closures. So administrative closures is pretty much what has been seen to be like a docket management where judges have been deciding that there is a case that they could remove out of their active calendar. And at this point, this is where we're going to touch a little bit on some of the cases, if we have time.
Yeah, we do.
Oh, okay, fantastic. I was trying to finish. Okay. I have shorter notes on the case. Okay. All right. So there are a lot of cases that have been decided very recently that are affecting the way that the courts are making certain decisions right now, and I think that they're worth highlighting. This is obviously something that, because it's so new, all of us are still really adapting and seeing how the courts are actually handling them. Matter of Castro-Tum was decided recently and essentially held that judges don't have the general authority to administratively close cases, and it narrowed down the cases under which judges are actually allowed to do so. So it cannot be just because no reason at all that I'm just going to close this case. Now they want them to look at particular things before they're actually able to move forward and administratively close a case. There was another decision that happened in June of this year, which is Pereira v. Sessions. Okay, and this had something to do with a stop time rule, and it applies to cancellation of the 10 years, but I didn't explain it at the beginning because I was going to mention it now. So when somebody gets a notice to appear and they're in court, a notice to appear is the charging document that it's how they tell you what the allegations against you are and the legal basis under which they're putting your removal proceedings. That document at the bottom should have the date and time of where the hearing is. A lot of documents, because they are done by let's say an officer and then later on transferred and done by the court, they were missing that information. The stop time rule means that the person has the burden to show that they've been here 10 years or more to qualify for this cancellation. Okay, but even if they were here 7 years and then they were given this notice to appear, usually the notice to appear puts a stop on you counting your 10 years. So the argument was whether the document had no date and time, how did that have the effect to stop your 10 years, your accumulation of your 10 years? So this decision said that it did not have the power to stop the 10 years, but it also made a reference to whether the notice to appear was defective or not, simply because it was missing the date and time. So some very clever attorneys decided that they weren't going to run with it and make some of these very creative arguments in court as to, well, if this is not good for this portion of this particular statute, this might also not be good to give jurisdiction at all. So people run to court and they try to set aside some cases and terminate proceedings. And within 2 months, now we got another case from the BIA that said, no, that is not what we meant. So it clarified, matter of Bermudez Cota. It just came out August 31st. I was graciously denied a motion 3 days after that. That it says that we're correct. It does not stop the running of those 10 years, which is great for those cancellation cases. But they also make that distinction that because even if that notice was missing information because it was followed up by a notice from the court of the date and time, that's enough to give them jurisdiction. So it limits the part of the argument to say that the notice to appear was defective in general it just allowed it to work for the cancellation. So, but for those 6 weeks, people were able to get away with some arguments, which was good. Some judges took it well, some didn't. But like I said, for the litigators, this is going to be a very interesting couple of cases that will give you an idea of where we are. Matter of LABR, it has limitations with immigration judges' ability to grant the continuances and enumerates the factors that should be considered prior to such granting. One of the factors that's included is DHS's position on the motion. This is something that they have considered in the past, but I think they're being asked with this decision to give it a little more weight. A lot of judges would exercise a lot more discretion based on whether they felt like this would allow somebody to seek relief, and now this is limiting a little bit more on their end. Matter of AB is it's the case that should be distinguished from the domestic violence that we were talking about, whatever we were talking about before, as far as asylum. So this case supposedly, and this is supposedly, and I'm saying it should be distinguished and argue, overrule ARCG, which is a particular social group for asylum on domestic violence. This was a very lengthy decision that a lot of practitioners feel like it was wrongly decided and should be argued. But two of the main points that we're talking about, and I think we were discussing this before, was whether it was the inability of the government to police private actors, and they're trying to say like we're having issues when the husband is abusing the wife, and the police is pretty much telling them go back to your husband. So some of the issues that we're seeing are like cultural in nature, and they're saying that that would not be enough to establish now a claim for asylum on domestic violence.
Can I just
Go ahead.
1 second? I mean, think of that in a little bit. Like we think about that deeply, right? So there's a court case that says they created this particular social group for victims of domestic violence in courts, right? It was litigated. Yet the Attorney General, in this weird, quasi-judicial system that we have that we call immigration court, which is administrative in nature, the Attorney General has the right to overrule a court's decision. I mean, and Melissa touched upon, the administrative closures and how the Attorney General has given guidance. And this is not me being partisan at all, but, you have to be aware of like the audience that you're dealing with. And for us that practice in regular Florida constitutional courts, I think a lot of us are like pulling our hairs. How can we have this suction of power from the courts being placed in this in the executive, directing these judges as to what to do? And so, you have this almost fear of some of these judges and closing these cases and administratively closures, which can benefit some avenues of relief in the future because they're getting this direction. And are they truly independent? Can they really decide cases in the manner that they should, right?
So we're running a little low on time for this section. So let's touch base quickly on the last case law update, and then we'll do some clarifying questions and then keep going.
Okay, matter of LEA, which is a better case, talks about being a family member could be recognized as a particular social group, and it has to do, it depends on the nature and the degree of the relationship involved, and how these are regarded by society. So some of the cases that may have to be distinguished at this point and cannot necessarily use the previous case law that was just overruled by the Attorney General, we could try to go ahead and use this to make the distinction. And one that's really hot off the presses that was decided 3 days ago, which is matter of SOG and FDB. Now it's also working on limiting also the power that the immigration judges have to terminate and dismiss cases. And it narrows down only to certain expressly identified regulations or where DHS does not meet their burden.
So let's take a couple steps back.
Right.
Just to make sure everyone understands. What's the difference between an affirmative case and a defensive case? What does that mean practically speaking? What does it look like?
Right. So an affirmative case is somebody that just came from Venezuela 3 weeks ago, and they were in the trenches and they tried to kidnap them, and now they're moving forward with preparing the application and filing an application with USCIS Asylum Unit. Okay? And waiting to see however long the application takes to be decided. And then there's another Venezuelan that came under a tourist visa and didn't file. They got stopped by the police and somehow got referred to immigration court, and now they're filing their asylum claim in immigration court. So they're both asylum claims, but one is being done defensively in front of an immigration judge, and the affirmative goes through USAS and to the asylum unit.
And what happens? So can an affirmative case become a defensive case?
Yes. So if an affirmative case does not go well and it gets denied, it's like getting two bites of the apple, because it will be referred to an immigration judge, and then you get to defend it in front of an immigration judge. You get to present the case again.
Now, we've talked a lot about a social group. You qualify for protection and you qualify for asylum if you can show that they're trying to kill you, murder you, rape you, etc., because you belong to a particular social group. What does that mean? Can I make up my own social group? Are there social groups that are not recognized? Are there terms that I should not use? Let's go a little bit more into the social group description.
So you could definitely create your social group, but why reinvent the wheel, right? You need to look at the things that have worked in the past and the things that didn't and why they didn't work. So when people say, when they talk about particularly for young children, Central American, we're talking about recruitment of gangs. Do not use the word gangs, right? We're talking about, an organized crime.
Transnational criminal organization.
There you go.
Transnational criminal organization.
Right. So a lot of the case law and a lot of the cases that have been denied are going to give you the clues to the things that you will need in order to be able to create that. The reason why we're making the distinction, let's say, of the matter of AB is because they're taking away a very strong social group that was helping a lot of domestic violence victims, and that's why a lot of people are very upset about it, because it took a long time to get there. And it may or may not be a cultural thing, but it's definitely happened, and one thing shouldn't take away from the fact that the abuse is still going on. So getting creative with how to now move that around and get other language that will still make it a group that will be recognized, a particular social group, is what we're being challenged with as far as using the cases now to distinguish and still make it one that should be protected.
Great. Any short, quick questions before we move on from this section? Great. Well, that was really great, Melissa.
Oh, that was a lot. I was worried about that. I could have really backfired things.
You enunciated and were easy to understand, so it was all good.
Thank you.
So that was probably our most difficult section, and now we're getting into our most interesting section. So
I have questions for you. So
I think maybe we can have a couple minutes.
Sure, no problem. We'll take a 5-minute break.
We hope you enjoyed our break, and we want to thank Holland and Knight once again for hosting today's seminar. We hope that all the Holland and Knight attorneys statewide and in the nation are able to see today's seminar too and pitch in with this pro bono effort that we've put on. We have a representative from Holland and Knight, Pedro. I want to thank you very, very much. And he's the president of the Haitian Lawyers Association. So this is a double blessing to us to have you here today and other leadership. And I know that you would like to just say
Absolutely.
a couple of words.
Absolutely. So it's an absolute honor to be able to deal with some of the issues that are impacting so many people. We thank you guys for the opportunity to be here and to be able to host such a impactful event. TPS is going to have a significant impact on a variety of different cultural communities, and there are going to be significant unintended consequences of what ends up happening once some of the rescindments actually go into effect. So, for example, Haitian TPS ends on July 22nd, 2019. The impacts of that, how do we deal with it? How do we take steps to effectively address it? The Haitian Lawyers Association in particular has taken steps to file a complaint against the Trump administration on the basis that the rescindment of TPS was unlawful and that it wasn't based within the statutory regime that was allowed. So we think that we're trying to move forward in a mechanism that allows us to combat the decision, and we think that we'll be able to achieve a goal that helps to ensure that our community will be protected and is able to move forward. I want to recognize Monique Hayes and the Wilkie Ferguson Bar Association for all the work that they do in the community. And I want to also recognize two of our past presidents, Lodi Jean and Patricia Elise for all the work that they did in helping to ensure that we had a bridge to be able to fight for this issue. And again, I thank you guys for all coming out, for learning about this important issue, and for all the teaching that is occurring. And I think this is the type of issue that as lawyers we should be engaged in. It's not just about making money, but it's about being impactful. So thank you guys so much.
Thank you so much. And thank you again to Holland and Knight. I also want to introduce the president of the South Miami Kendall Bar Association, who's here today and is also one of our sponsors. To please stand, Josh Jones. And for the other voluntary bars, the Miami-Dade FAWL and the Caribbean Bar Association and Gwen, I know that there are other leadership here today from those associations, so we thank you. And if you would like to rise and be recognized. Groups we are working with. And again, we're just very blessed on behalf of the Dade County Bar Association, Legal Aid Society, and thank you very much again for being here.
Great, thank you. So we're going to go ahead and continue with our program. Our last section is literally the most interesting one because this is where you get to think outside of the box. This is where you get to be creative with your clients to try to see if you can find maybe an exception or a back door somewhere legally to achieve your goal of getting them that green card, of getting them that pathway to become a U.S. citizen. So our last speaker is Adonia Simpson. She graduated from the New England School of Law. She currently works for the Americans for Immigrant Justice as a director of the Family Defense Program, where she plans and executes community legal screening clinics and Know Your Rights presentations. Now, before she begins her section, she'll go ahead and give you some more information on these flyers that you should have, which is a list of legal clinics that we hope that you guys take advantage of, especially the local bar leaders. She also oversees a staff of 4 in providing direct representations to clients in defensive and affirmative applications. And she's a frequent speaker on immigration issues in South Florida. And just one more bit. She's admitted into the Massachusetts Bar, and she currently serves as the AILA South Florida Vice Chair for the EOIR Committee, as well as the co-chair of the Unlicensed Practice of Law Committee. Thank you, Adonia.
Thank you, everybody. So really quickly, you should have all received one of these flyers, and I find it so timely given the discussion that we're having today, because one of the purposes of these legal screening clinics are there are so many people that do have alternative options beyond TPS or DACA, or just if they're undocumented, they may have options right now, without any sort of reform, without any changes in law. So what we're really trying to do is identify those individuals and get them on that pathway to permanency and safety. There's, we've talked about the changes that we've been seeing. There's a lot of fear in the community. And even if people come to an event and find out that they have no options, in my opinion, they're still in a better place because hopefully they're not going to get scammed. And I'm going to talk about that towards the end of the presentation about some of the horrible things that we're seeing. So if you're interested in volunteering, we have a volunteer link. If you're interested in sponsoring an event, please come see me. It's a great way. You don't have to be an immigration attorney. We do have immigration attorneys that will provide the expert experience. We have a great screening form where you'll actually get to sit down one-on-one with somebody, elicit the information, and take a lot of this that you've learned today and actually put it into play and start thinking about it. So find me after, okay?
Adonia, we're going to send the link and the flyer to today's attendees along with the PowerPoint. So
fantastic.
We'll do that electronically as well.
Fantastic. And speaking of the PowerPoint, when you receive it, you might see that there are hyperlinks in it. Click them. We put in a lot of practice advisories and additional information. Immigration law is dense, and we can't fit it all in a PowerPoint slide, so we tried to give you some helpful resources throughout the presentation. As immigration attorneys, we love acronyms. We kind of forget that people don't necessarily know what everything means. So I want to take 1 minute to talk about the immigration system because it's going to be important as we move into these kind of more creative forms of immigration relief. So there's 3 agencies that really are involved with immigration. You have the Department of Homeland Security. That holds USCIS, U.S. Citizenship and Immigration Service. Those are the folks that are processing your affirmative applications that Melissa talked about, your affirmative asylum applications, your naturalization applications, your family petitions, adjustment of statuses. That's the affirmative, benefits processing center. Then you have Customs and Border Protection. Customs and Border Protection is at the airports and around the border. The border is not just the land border, but it's a water border. So the whole state of Florida is actually within the jurisdiction of the Customs and Border Protection. Besides the enforcement aspects of immigration that they're involved in, they do work around customs and, products and goods coming in, and they have a lot of functions beyond immigration, but it's kind of become a big part of what they do nowadays. The last agency within Department of Homeland Security that's worth mentioning is ICE, Immigration and Customs Enforcement. ICE is the enforcement arm of the Department of Homeland Security. I like to call them the police and prosecutors. They're the people that are out oftentimes conducting raids. These are also the prosecutors, our opposing counsel when we're in immigration court. They're ICE attorneys. So that's DHS. The immigration court is not an Article III independent court. It's within the Department of Justice. So as Lodi was talking about, that means that their boss ultimately is Jeff Sessions. So he's been referring all these cases and really kind of changing the structure and landscape of immigration law. And as attorneys, I think we can all say that it's been a rough few months with some of the things, and we're having to get really creative. So within the Department of Justice, you have the immigration courts, and you also have the Board of Immigration Appeals, which is the appellate body of the judges. And then the final agency that you might be working with when it comes to immigration is the Department of State. So all of your consular processing, things like that. Lodi talked about consular processing and 601A waivers. Anytime anyone leaves the country and is applying for some sort of benefit to reenter, it's the Department of State that's involved. So that's just a quick kind of recap. And the reason this is important, and going back to several of the panelists have talked about the importance of the Freedom of Information Act. When you're looking at creative immigration relief, it's really important not only to do a FOIA on your client, but to potentially your client's family members. Because we sometimes forget that there's sometimes these other things that may be available besides the standard family-based petition or asylum application or things like that. And also to seek these other, whatever remedy you want to pursue for your client, you want to make sure that you understand the procedural posture. Where are you at? Who has jurisdiction? What do you need to do? Particularly with people that have DACA and TPS, it can get really complicated because I think, as Peterson maybe mentioned earlier, a lot of these clients have maybe gone through the process. Maybe have already applied for asylum and they got denied. And by virtue of getting TPS, everything was kind of put on hold. So that makes it incredibly complicated. So you do want to understand where your client's been so you can figure out where you need to go. So, and for example, one thing Melissa talked about was this Supreme Court decision, Pereira v. Sessions. It's huge for a lot of people that have temporary protected status because maybe they went through the process and they were denied asylum by the immigration judge, and maybe they appealed to the Board of Immigration Appeals. But at the time when they applied, they'd only been here a year, maybe. But now, maybe they've been here 10 years. And suddenly we have a new form of relief in play, which is the cancellation of removal that Melissa was talking about. So there might be a basis to do a motion to reopen, but you can't do that until you know exactly what happened to your client. Okay? So we're going to talk about some other forms of relief that we oftentimes forget about. One thing that's not on the slides that I do want to mention is derivative citizenship. You'd be surprised how many people are actually citizens of this country, even if they weren't born here. And it's something that you always want to make an inquiry to as far as the status of people's parents. If they're U.S. citizens, when did they become U.S. citizens? How did they become U.S. citizens? You may have a client that doesn't need to go through any of these processes because guess what? They're a citizen. Doesn't happen all the time, but it can happen. The Immigration Legal Resource Center, ILRC, has an amazing chart. There's been several versions of the law about deriving citizenship from your parents, and so it's a little complicated. I'm not going to get into it. The chart is fantastic, and it sets out the elements that you have to have, depending on what version of the law you're looking at, when the person was a minor, and the elements that they have had to have met before they turned 18. So it's an amazing chart. So always keep that in mind. Derivative citizenship. Why do any of this if you can prove they're a citizen? So something else I wanted to chat about that's not on the slides, and this is important about procedural posture and what your client's history with immigration is because a lot of particularly Haitians who have TPS or people that have traveled under advance parole are considered an arriving alien. And that may not make it, you might think, well, what's the big deal with that? But somebody who's designated an arriving alien means that there are certain applications that are solely within the jurisdiction of USCIS, the Affirmative Benefits Processing Agency that we talked about earlier. So, for example, if somebody is in removal proceedings and they've traveled under advance parole or they were designated an arriving alien when they entered, the immigration judge doesn't have jurisdiction to do certain things. Like the immigration judge can't actually adjudicate the adjustment of status application. So with all these decisions that Melissa's talked about, it can become a little bit more complicated because you're asking for continuances or you want a termination, and these things might not be as easy to get in order to process with USCIS. However, if somebody has a final order of removal, you might be able to go through this process because they're an arriving alien, and you can ask for a special waiver if they have a removal order. And it's pretty, I know, Peterson, you've done a ton of these cases, and it's been pretty successful, right? So that's just another thing I wanted to touch on. So that's why it's so important to FOIA, so important to understand, because you can do a lot of damage going forward with an application that maybe that's not correct. So let's talk about some other forms of immigration relief, for particularly that we see for folks that have TPS. NACARA. I'm not going to get into the details. There's a lot of text here. Y'all can read. There's a lot of practice guides online. But essentially there was a settlement way back in the day. And if you were a member of this group, if you'd filed for an asylum application and you're from El Salvador, or it's El Salvador and Guatemala, right? You might have been able to get your status through this NACARA program. Every once in a while, you'll see somebody that's a principal beneficiary, but actually more frequently, you'll see people that are what's called derivative beneficiaries. And this goes back to really understanding what's happened to people's family members. So maybe the parent got NACARA, and maybe the child who has TPS may be able to be a derivative beneficiary on that NACARA application. It can get tricky, but it's something that you want to keep in mind. There's amazing practice guides on this. So I think the main thing is recognizing that this might be an option, and then do the research and see if it will apply to your client. So what's important to know about derivative beneficiaries is it has to be, it can't be an after acquired. That means like, a spouse that you married somebody later after you got the benefits. It has to be, the relationship has to have existed at the time that the principal, the initial applicant, got the benefits. But they're great applications. Like I said, you see them every once in a while, and it's always like finding that diamond in the rough. You get really excited when you find this kind of very obscure application to proceed with. So that's NACARA. And then next we have HRIFA. This was actually kind of the response to NACARA. I feel like a lot of times, the Haitian community is really left out in a lot of things. They are suffering similar, if not worse, conditions as maybe some of the Central American countries, and it takes kind of a little bit of time for there to be advocacy around getting a similar benefit. So I kind of think HRFA is a little bit like NACARA. With this, you're going to see more derivative beneficiaries. So once again, parent, spouse, did somebody else have benefits, and did they receive their green card based on this program? And if so, could they be eligible as a derivative? Both NACARA and HRFA is all kind of revolving around the fact that asylum applications back in the 90s were taking forever to process, and there was litigation, which once again is what's beautiful about what's happening now around TPS and DACA is all this litigation. We don't know what's going to come out of it. There could be some really good things. This litigation and things that happened around asylum applications that were pending so long in the 90s really gave a group of people an avenue to pursue a green card. So here's all the requirements for HRFA. As I said, y'all can read. And there's great practice guides online. Before I wrap up, I'm actually going to give you some great free resources where you can find some information on everything that you've heard today. So, U visa. There's a whole body, oftentimes I put immigration law into kind of different buckets. So one bucket is your family-based bucket where there's, family petitions or relief is predicated on having a family relationship or a qualifying relative that's going to suffer a hardship. The second bucket I like to think of as the humanitarian bucket. This is the bucket that really helps people that are in difficult situations. So Melissa talked about asylum. That's a humanitarian form of immigration relief. But there's also kind of victims-based relief. So Lodi and Melissa talked about VAWA, the Violence Against Women Act, which has many different things that are involved in that. And I should note, despite the name, it is available for men too. Men too are victimized. But one of the other victim-based reliefs is the U visa. So the U visa is for victims of certain qualifying crimes. It has to be something a little bit more serious. There's going to be a slide coming up that lists all the qualifying crimes. But you do have a lot of ways to make arguments there. The big requirement for the U visa is that you had to have cooperated with the investigation or prosecution of the case. So if you have a client that was victimized and never called the police, that's a problem. And it's difficult now because so many people are afraid. They're afraid of law enforcement. They're afraid if they reach out to law enforcement, they're going to get detained or deported, even if maybe they have TPS. They may be afraid. So there's a lot of counseling involved, encouraging people to reach out if they're victimized. There might be occasions where you can actually make the report afterwards and work with law enforcement to try to move forward. The big barrier I find to the U visa is one of the requirements to even file is getting a certification from law enforcement. And you'd be surprised. Huh?
The slides are jumping ahead of us.
Oh, no, it won't stay.
From law enforcement in the other country?
No, law enforcement here. So the crime had to have happened here domestically. The purpose of the U visa, it's really, I like to tell clients, the U visa isn't really to help immigrants, it's to help law enforcement. It's supposed to be a carrot to ensure that people come forward and prosecute, and report crimes and work with the prosecution of crimes. But the downside of that, here's this carrot for people to come forward, but there's unlimited discretion with the law enforcement agencies as to whether or not to complete the certification. So for example, Broward County Sheriff's Office, if you have a client who was a victim, I have a client who was a victim of a carjacking, young girl, DACA, cancer survivor, amazing young woman, victim of a carjacking, they never made an arrest. So there's no prosecution. So we can't get the state's attorney involved because they're not involved. And the sheriff's office has said, since there's no arrest, we're not going to certify. It's rough, right? But you really have to craft your arguments. And sometimes a case you might look at it and think, well, it doesn't really fit into one of the boxes is the qualifying crimes. Is that the one before? It keeps jumping? Yeah. Okay. Here's all the qualifying crimes. I think I had an earlier presentation that was on a timer, and when I cut and pasted the slides, it brought the timing over. So I apologize. I think Christy might be able to fix it if she exits out of it. But there's certain qualifying crimes. So, for example, like maybe somebody was robbed, and they were robbed with a dangerous weapon, a gun. that's arguably a felonious assault. You might have to get a little bit creative. Where we've seen a lot of creativity is around fraud, notario fraud, arguing that maybe if the notario was threatening to call immigration, there's an element of witness tampering. You can get really creative with this, but the downside to it all is you can't go anywhere with it unless you get law enforcement on board and they're willing to certify. What I try to tell law enforcement agencies is you are not adjudicating the visa, you are not giving this person benefits, you're giving them an avenue to apply. All that the U visa certification says is that this person was a victim of a crime and that they cooperated, right? But because of the discretion, you'll see less immigrant-friendly law enforcement agencies perhaps declining to do it. A second downside to the U visa is just like the preference categories that Lodi was talking about, where there's like a certain number given every year. The U visa, likewise by statute, only gives 10,000 visas a year. Do you guys think that there's only 10,000 victims of crime, immigrant victims of crime every year? No. So what happens is there becomes a backlog. Right now, there's some estimates that say if you apply for a U visa today, it might be anywhere between 5 or 8 years before it gets adjudicated. And you don't get a status in that time. It's just like any other petition, like a family-based petition. Yes, there's a petition pending, but it's not officially giving you a status. Sometimes they'll make a deferred action decision where you can get deferred action, kind of like the DACA kids, that will give you work authorization, but it's still not an actual status. I think just answered it. Okay, perfect. So that's the U visa. The links in here provide the forms that need to be completed and the process. The great thing about U visa is there's a lot of eligibility for derivative benefits. So when you're screening people, you're not only asking, are you a victim of a crime, but was your child, parent, spouse ever a victim of a crime, right? Because maybe your client wouldn't be a principal beneficiary on a U visa, but could be a derivative beneficiary. So this is where you always want to keep everybody in mind. All right, so that's the U visa. And then let's talk about the T visa. So the T visa is something else that happens. One thing I want to make really, really clear, I think a lot of people, when they think about human trafficking, they automatically think of sex trafficking, which is horrible and it does happen. But the bigger issue when it comes to trafficking is actually labor trafficking. Particularly here in South Florida, we see it in the farming community. When I lived in the DC area, we saw it a lot in the diplomatic community, like as far as like household help. So yeah, those really interesting cases. So the T visa is for survivors of human trafficking. And generally the trafficking had to have occurred here or that you're here because you were trafficked. And there's two buckets, the sex trafficking and then as far as labor trafficking. And there has to be some sort of element of force, fraud, or coercion. So in the context of labor trafficking, it could be, somebody's documents are taken from them and they're not returned or they're not allowed to go anywhere. Or maybe there's the threats to call immigration if they tell somebody that they're not getting paid. We've had clients that were injured on the job and they were told that they couldn't go to the hospital, and if they did, they would call immigration. There has to be this sort of force, fraud, or coercion in the labor sense. And then when it comes to sex trafficking, y'all can read it. It's for Commercial Sex Act. There's different rules relating to minors because minors cannot make any sort of consent or decision around this. So you really also want to see when things happen because there might be laxer rules in regards to your client if they were a minor when they were trafficked. Unlike the T visa, you don't have to have a certification, but it certainly does help. It does make it a stronger case if you can get a certification from law enforcement. A lot of our cases are certified by Homeland Security Investigations, which does a lot of the investigation of human trafficking and smuggling. So that's the upside, is you don't have to have the certification like you do for the U visa. Another upside is even though there's a limit, it's never met. So, per year, I don't think it is. I don't think I've ever had, it's not been met recently.
5,000 hasn't been met.
Yeah. So it's much more quickly, and they're much more quicker processed, and there's potential benefits of getting continued presence, which gives you a status and work authorization temporarily while things are pending. There's a lot of, and there's also other benefits as far as accessing certain resources, public resources, if you get certified as being a survivor of human trafficking. So sometimes you're looking at a case. We've had clients that tick like 3 or 4 boxes when it comes to relief. So one of the things you're going to be evaluating is, what does the client want to do? What's going to be the quickest? What's going to get them the most benefits? And what may get them the most benefits for their family members? T visas as well. Derivatives can apply for benefits. So spouses, children, parents, depending on the situation, may be able to benefit and get status. U visas and T visas do have a pathway to residency. They differ as far as how long you have to wait to be able to do that. But at least there's a light at the end of the tunnel. So these are not necessarily the quickest options for people that have TPS and DACA, but it is an option. All right. So those are the victim-based reliefs. So there's a lot of, I've included hyperlinks. You guys can buzz through and read more. So there's a lot of other things that you've probably heard of in the news that I just wanted to touch on because it could impact a lot of the types of relief that we've talked about today. So one of the things that there's been a lot of discussion about is a change in regulations regarding public charge. So anytime you're seeking to get your green card or you're seeking a visa at the consulate to immigrate to the United States, there's a determination being made as far as whether you're admissible, whether or not there's anything that should prevent you from coming here. And obvious things are criminal convictions and things like that could be a barrier. But one thing is the government doesn't want to admit people that may become a burden. So traditionally, what happens is you do something called an affidavit of support. There's a person that sponsors you. It's usually the spouse or the petitioner. If they don't make enough money, you get a joint sponsor. And if you can show that they make a certain amount of money or have a certain amount of assets and that they'll be able to support you, they do the affidavit of support, which is a contract with the government saying, I will support this person for 40 quarters, 10 years, or until they naturalize, whatever comes first. Now, what's the proposed regulations that have been leaked are now stating that they're going to take a lot more other things, and it's going to become kind of a cumulative balancing look. So the affidavit of support, yes, is one factor, but they're going to be looking at the immigrants' age, employability, education. But the troubling thing that we're very concerned about as advocates, they're going to be looking at benefits received by family members. So generally, immigrants aren't eligible for immigration benefits. There's some exceptions that we won't get into today, but generally, they're not. But their U.S. citizen children might. So this is something that has us concerned, first of all, because we see more and more people not enrolling their children in safety net programs for which they're eligible to ensure that we have healthy, happy kids. But also there's a lot of concern that if they apply for immigration status, they might not get it because their kid has gotten in the past. We're still waiting for those regulations to come out. They haven't come out. We're ready to make comment. If you guys hear about it, please comment and say your 2 cents on the issue. It's just one more barrier that's going to make it more difficult for some people to get status. Some other things that we've seen that are going to be impacting people seeking benefits, USCIS, the affirmative benefits processing, has issued guidance about how they're processing applications. So now they're saying that a lot of times if you were missing some information, they would send you something called a request for evidence, an RFE, or a notice of intent to deny, and annoyed. Now they're saying if you're missing an essential element of the application and if it's not there, they're just going to reject it. They're going to deny it. I'm sorry, difference than rejecting, which means they'll take your money. They'll take your money, and then they'll deny you. And then that goes hand in hand with another USCIS policy regarding notices to appear that everyone's talked about earlier, the charging document that starts removal proceedings. So now they've issued policy guidance saying, we're going to start serving notices to appear on all these people. So you have people that are probably going to get denied without a chance to respond and then put in court and then having to deal with everything that Melissa was talking about, all these crazy attorney general decisions that are really making it more difficult for people to find relief. So earlier everyone discussed the AG decisions, but also another thing that's kind of impacting the way courts are being processed is starting in October, there's going to be quotas. So since the judges aren't independent, the Department of Justice has said, you're going to have to process and close out a certain amount of cases a year. So there's a lot of discussion about really is this, what is this doing to the unbiased adjudication of applications before the courts. And then finally, family separation got a lot of attention with what was happening at the border. And that was horrible and horrific. But I do want to remind everybody that what's happening with DACA and TPS, that too is family separation. We're looking at potentially over 1 million people being torn apart from family members. If we don't get a solution, if we don't get people on a pathway to residency, people have been here decades. And in decades that you've been here, you put down roots, you pay your taxes, you have kids, you have a business, you buy homes, you put down roots. So we're going to be seeing family separation in our local communities. We've been seeing it already, increased enforcement and detention. The people in our detention centers now have changed drastically in the last year and a half. As opposed to recent arrivals, we're seeing a lot more people that have been in our community longer. Would you say that's true, Peterson?
Absolutely.
Yeah, absolutely. And then the final consequence to all of this that I hinted at earlier is because people are so afraid and because the law is complicated, there's a lot of fraud. So in many Latin American countries, a notario is an attorney. Here, you all know this. Notarios aren't attorneys. An attorney may be a notary, but there's this connotation that notarios are able to do legal practice. So you'll see a lot of scams. You'll see people be bilked for tens of thousands of dollars, applying for benefits that they're not eligible for, which combine that with the policies we were talking about, guess what happens? They end up in removal. Right? So I oftentimes tell clients, I'm like, best case scenario, you lose your money. Worst case scenario, you may be indefinitely separated from your family when you're deported.
Or get a U visa.
Or get a U visa. U visa, it's kind of tricky to get somebody to certify it because you need that investigation and prosecution. But yeah, we try U visas and they're tricky because one of the things that you have to establish for a U visa is that there's been some sort of harm. So my argument is, people being concerned about being separated from their family and the stress of being in removal proceedings and all this, it's a psychological trauma, right? So we're going to be seeing an increase in notarial fraud. Report it if you see it. There's, committees with AILA, with the Florida Bar. There's a lot of places that you can go. And then the last thing, whenever you work with clients that have TPS and DACA or any status, you really need to have a very honest conversation with them. They need to have a plan. Statuses can end, things can happen. They may be driving without a license and go in detention, and things happen every day. And it's almost like making a will. You really want to have to think, if the worst happens, what do I want? And so you really need to encourage clients to have this conversation within their families. So what happens to the kids? Do they want to consider doing a power of attorney? Have they identified somebody who is responsible, that is able to take care of their kids? And if they have they actually talked to that person to make sure that they're willing to take care of their kids in the event that they're detained or deported? Do they want their kids to return to home country with them? We know earlier we were talking about the resources to actually round everybody up that has TPS when it ends and deport. I agree with Peterson. I don't think that there's really those resources, but I do think there may be some people that make the decision that they're just going to self-deport, that they're just going to leave. Particularly with the climate, the way things are, it's hard. So you may see people making the decision to leave, and they're going to need to get passports for their kids and take their kids with them. So not only children, but property. If you're detained, sometimes you may get a really high bond set for you to get out of detention. So you may want to have somebody have access to your resources. If you do get deported, if you have a house, if you have a car, what happens to that? Do you want to get a power of attorney? And these are all difficult decisions that people need to talk about. And then I always tell clients, make sure that we're doing FOIAs on everybody. Anybody that's had any sort of touch with immigration, even if there's nothing to do right now, we want to make sure that they have a history, that they have their history. It comes on a CD. So we FOIA everyone and we tell people, keep all your important documents, not only in just a safe place, but a safe place that somebody can access in the case that you're detained or deported. Detained cases move very rapidly and we need a lot of information to be able to proceed. So we want somebody to be able to get it so we can try to help as soon as possible. So, and then we already talked about that. Free legal resources. There's a lot of amazing nonprofit organizations that have things free that cover all this. They put out practice guides as there's changes in the law. So please check out all these folks. Sometimes they have trainings and webinars if you want to take a deeper dive into some of these topics. But please use them. Thank you.
Okay. We only have about 5 minutes left. I wanted to ask everyone just maybe 1 or 2 simple questions, and we'll go ahead and wrap it up. The first question is, immigration is extremely confusing. You know, you have law, you have the INA, you have the HCFRs, you have policy, you have case law, federal, state, etc. How would you guys advise the new immigration practitioners, how would you advise them on keeping up to date and just getting a basic understanding of how to approach immigration?
I mean, I'm a member of AILA. There's no need to reinvent the wheel. But, you know, they send out updates in the law. You know, what I do a lot is criminal-based, and you can only imagine there's 50 states, 50 different statutes, right? And we're comparing it to the federal statute. So, you know, you've got some really great professors that head up the law clinics. Danya, as you can see, is a great resource. She does a lot of research on a variety of issues. And so, you know, take advantage of joining AILA. Take advantage.
What's AILA stand for?
American Immigration Lawyers Association. Acronym, again. So, and, you know, each university down here has an immigration clinic, and there's a professor there. And some of them are doing oral arguments at the 11th Circuit, you know, creating law for us. And they will pick and choose the cases that are ripe for decisions, you know, in the appellate courts to make sure that they preserve the issues for the benefit of us practitioners and our clients.
And just one last question. What are some tips on representing TPS in DACA folks with USCIS or with in immigration court? Do you guys do anything differently? Do you prepare a little bit more? Do you have an extra memo handy just so that the immigration officer is on the same page and understands? Do you guys do anything differently for your TPS clients than you would just for a regular immigrant that's here?
Verify if the person traveled with an advance parole or not, and whether there was a final order or not will obviously make a difference if something will have to be reopened to adjust or just go with an inadmissibility waiver. You have to do a bigger analysis, I think, at this point. And some of these people have been here 25 years before they were granted TPS. So what happened there? How did they come in? Sometimes after getting a FOIA, you decide not to move forward. That happens.
A very good point. Any last comments before we end?
I just want to thank everybody again today for being here. We have a certificate of appreciation for each of our speakers. And please make sure that you're signed in. Everyone who's here today will get the email with the CLE again, the agenda, and all of the materials, the flyer for the upcoming clinics with AIJ and Catholic Legal Services, and other opportunities to do pro bono around the state. Thank you again, and thank you so much to the Dade Bar Immigration Committee.
Thank you. Thanks everyone for coming.
Oh, thank you.
I need that.
Thank you.